On the morning of October 27th, I prepared to meet the prospective Section 8 tenant for the first time. I had already communicated with the homeowner about outstanding things about the property condition that needed to be done before the property could be rented. Who would be responsible for the utilities, road maintenance, propane procedures, yard maintenance, junk removal, cleaning. Also discussed the security deposit and when rent would be due. All things that would need to be included in his lease. I also communicated with the social worker, the person who was helping the tenant get placed in a home. She told me that the tenant planned to arrive at 11 a.m. She emphasized that the tenant was specifically looking for a rural property and that she currently lived in a rural area and had one living caregiver. I also wanted to disclose to the social worker that we were still preparing the home and it still needed some junk removal and professional cleaning, and that the water was temporarily turned off because the home had been sitting vacant for several months. As the tenant traveled to the property by Lyft, she began to communicate with me via text message. There were a lot of text messages coming from her, so I'm going to continue sharing the content of those text messages. She explained that Lyft was paying her driver $30 for the trip, and she was convinced that his actual out-of-pocket cost was around $32. She described Lyft's compensation practices as criminal and stated that the company had multiple lawsuits pending against it. She further stated that it was only a matter of time before the Labor Code Enforcement Unit took action and imposed substantial fines. The tenant then stated that she was personally suing Lyft over what she described as a felony hit and run involving her as a pedestrian. She identified that her attorneys were the Law Brothers. I continued to text her and I mentioned that the property was just under 5 acres. She said that she had a neighbor that wanted to rehome 5 goats and would speak to the neighbor about maybe taking on a few of them. The showing went very well. She loved the property and told me she wanted to move forward with tenancy and requested the Section 8 paperwork be started. She also said she planned on asking her physician to write a prescription for 2 bathroom remodels and believed Blue Shield would pay for the work as a disability accommodation, remodeling the upstairs bathrooms, installing an electric chairlift, and making modifications to the stairs to accommodate the lift. She then asked whether the homeowner would approve a temporary solar system that would attach outside to a separate hub rather than being installed on the roof. She stated that she would be responsible for the cost and installation. That she believed insurance would pay for ADA improvements to the driveway, including concrete or stone access leading to the gate. She asked whether pigs would be permitted on the property because one of her neighbors wanted her to take them. She also advised that she had a sulcata tortoise. She later described Franklin as an escape artist, and he did in fact eventually escape and has not been found. She had known her current neighbors for approximately 25 years and that the neighbor was a deputy sheriff. She discussed bringing both wood and metal fencing to the property and stated that she would need to inspect the land with her ranch hand to determine where the animals should be placed. I explained that the homeowner might eventually return to California and place a manufactured home on the lower portion of the property near the front gate. I advised that the homeowner wanted a long-term tenant and did not intend to interfere with the tenant's use of the main property. The tenant responded that Section 8 would pay for her lifetime use of the property and joked that she did not know what could be more long-term unless she reincarnated, adding that she believed in reincarnation and might return as a goat. She was not prejudiced, had traveled throughout the world, spoke 5 languages, and evaluated people based on who they were. That many foreign men considered her highly intelligent and believed they enjoyed speaking with her because she was well-traveled, well-educated, and polite. The tenant requested additional videos showing the different fenced portions of the land so she could plan how to organize and use the property. She asked whether she could install gardens for vegetables and herbs, plant fruit trees, grow grapes, and establish a vineyard. She stated that she would install a drip irrigation system to maintain the planting. She also discussed adding grass to the backyard and replacing or adding kitchen cabinets. That she knew someone who wanted to use approximately 1/2 acre to 1 acre of the property for organic gardening. She explained that the person would maintain and water the garden and that both she and the homeowner would benefit from the fruits and vegetables produced. She sent me a link to an ADU-style home that was $7,000 and discussed possibly installing an ADU for her ranch hand, that she was experienced with legal matters and believed she could independently handle permitting and easement issues. That based on her research, a large shed or barn could be constructed for agricultural use without permits. She further stated that showers, toilets, a small kitchen, and overnight accommodations could potentially be included while still avoiding the permit process, that the structure could be labeled as a barn or shed so that planning fees, permit requirements, taxes, and reassessments might be avoided. She discussed the possibility of using such a structure for her ranch hand and suggested that the homeowner could potentially build a similar structure for his own use on another portion of the property. Tenant then brought up the possibility of a future purchase of the property. She referred to a first option to purchase, trust-to-trust transfers, seller financing, bank financing secured by a note, leasing the property back to herself after ownership was established, and the possibility of continuing to use Section 8 payments after a future transfer. She said that she had worked for an attorney who was currently deceased, and that he had taught her about special trusts and legal strategy, that they had practiced at state, federal, and Supreme Court levels, that the homeowner could rely on her to either know the answer or find multiple possible answers. Tenant later acknowledged that she might be overwhelming me and that her mind was working overtime. I responded that I had just returned home and could review the messages and discuss the proposals with the homeowner. She thanked me for my patience and kindness. She stated that she was excited but not in a rush to physically move in because of her health limitations, that Section 8 would pack, move, and unpack her belongings, and that she was well taken care of. Later that evening, the tenant sent additional messages regarding the existing hot tub, that she wanted the hot tub to remain, that she would repair it if there were problems, and that she would accept responsibility for it. She also proposed constructing a masonry block enclosure around the propane tank, that the enclosure would provide fire protection and prevent animals from damaging the tank, installing a door for access, and placing 4x4 posts into concrete brackets to support a decorative roof resembling a wishing well. Throughout the day, I advised the tenant that proposed alterations, improvements, structures, and uses of the property would require the homeowner's review and approval. By the conclusion of October 27th, the prospective tenant had sent me 51 text messages concerning the showing, her transportation, her disability, proposed accommodations, livestock, land use, property alterations, future structures, legal strategies, and possible long-term ownership of the property. How did I respond? I reached out to the social worker and I reached out to the homeowner to express my concerns.